wish, support us with a donation by going to our website, peacenowcanada.org. Our webinar today is Fighting De Facto Annexation Through Israel's Legal System, Challenges and Prospects. Our speaker is Israeli human rights lawyer Michael Sfard. The webinar will run about 1 hour and 15 minutes, so until 1:15 p.m. We welcome your questions. I will try to get to as many of them as I can, so please type these in at any time using the Q&A feature at the bottom of your screen. Please don't use the chat for questions. If you wish, tell us where you are writing from when you type in your question. Our webinar will be recorded and posted to our website. Today, our guest moderator is David Cohen. David is a Canadian Friends of Peace Now board member and active in our Montreal chapter. David, over to you. David, you have to unmute.
Sorry. I'm pleased to introduce renowned Israeli human rights lawyer, Michael Sfard. Michael is an expert in settlements, international human rights law, and the laws of war. He has championed many high-profile cases in Israel. He has represented before Israel's Supreme Court a variety of Israeli and Palestinian human rights and peace organizations and activists. He is, among others, the legal counsel for Peace Now. During his military service, Michael became a conscientious objector and spent 3 weeks in military prison due to his refusal to serve as escort for Israeli settlers. Born in 1972 in Jerusalem, Michael Sfard is a grandchild of Holocaust survivors. He obtained law degrees from the University of Jerusalem and from University College London. He has published numerous articles in leading newspapers and legal opinions, co-authored several books, and is the author of The Wall and the Gate, Israel, Palestine, and the Legal Battle for Human Rights, which came out in 2018. CFPN has asked our guest speaker a series of questions in order to shed some light on Israel's legal system as it applies to the occupied territories. Michael, it is an honor to host you, so thank you for accepting our invitation. You have about 30 minutes to answer a series of questions. And at the end of your series of responses, I will ask you a couple of follow-up questions, and then the audience will be allowed to ask you a few questions, as Gabriela mentioned. First, Michael, in order to provide some general context, how is Israeli law applied to the occupied territories?
Well, good evening from Tel Aviv. Here it's evening, and thank you very, very much for inviting me. Thank you, David, for this very generous introduction. I'm so very happy to be in this webinar and to see so many people that care about these issues and that have looked into this webinar. So thank you all for joining us. I think before I'll answer the question on how Israeli law is applied to the occupied Palestinian territories, I'll say a word about the status of the occupied territories under international law. As you all know, the West Bank, East Jerusalem, and the Gaza Strip were all conquered, occupied in 1967 by the Israeli army. International law knows the reality of occupation. It does not outlaw occupation, but it does regulate the conduct and the powers of an occupying power in an occupied territory. So occupied territories an occupation is a status, is a legal status which confer rights to those who are occupied, who are the residents of the occupied territory. It provides powers and obligations to the occupying power and the occupying army. And according to international laws of occupation, which are part of the general laws of war, the military commander of the occupied territory is vested with all powers of government. The military commander of the West Bank, for example, is the legislator of the West Bank. And when he or she signs an order, this is primary legislation for the occupied territory. He or she, it's a bit funny to say he or she because we never had a she in this position. So he, the military commander, is also the executive, naturally, and the judiciary. Military courts are set in the occupied territory. And all of these powers are vested with the occupying force in order for them to be able to implement the main obligation that international law imposes on an occupying power. And that is to manage the occupied territory in a way that will restore security and civil life for the duration of the occupation. An occupation regime is, according to international law, a temporary one. It is not sovereignty, and it is a kind of trusteeship in the sense that the occupying power has a trust, and they have to use the trust for the benefit of the occupied people, and of course, for the security of the occupying power itself. So an occupation is a temporary regime that is set to allow a management of the occupied territory for the duration of the occupation until it ends. And the occupying power is not supposed to make any significant changes in the occupied territory. Israel has done many things in the last 54, almost 55 years, in which that run against the main idea, the governing principle of the laws of occupation, the principle of conservation, the idea that you should not make any changes to the territory. And so whenever, if any of you will come to the West Bank, they will see immense changes in every possible aspect, any possible layer of life to the occupied territory since 1967. Some of these changes have been done because of the flow of time. Roads had to be fixed and widened, and electricity lines had to be set. But many of the things that you'll see in the occupied territory have been done in a direct violation of international laws of occupation. And the main one, and here I'm coming to your question, David, I'm sorry that it is a long answer, but the main thing that violates the laws of occupation is the immigration of Israeli settlers into the occupied territory. And Israel has not only allowed, but actually incentivized and built settlements and created the infrastructure for hundreds of thousands of Israelis to move, to immigrate from Israel to the West Bank, creating, and in the past to the Gaza Strip as well, re-engineering the demography of the occupied territory. And when this is an act that is specifically prohibited in the laws of occupation. There is a specific provision in the Geneva Convention, in the Fourth Geneva Convention, which lays down the principles of the government of occupation, which makes it illegal under any circumstances and with no exceptions to allow the movement of citizens from the occupied territory into the from the occupying power into the occupied territory. Now, there are many reasons why this prohibition was created. One of them is and I'm getting now to your question, David, is that when citizens of an occupying power are living in the occupied territories, you create two sets of communities. The occupied people, whose political and civil rights have been suspended for the duration of the occupation. They do not have a right to vote or to be elected or run for government. And they are under the rule of the military that occupies their land. And then you have another community of the citizens of the occupying power, Israeli citizens, the settlers, who are vested with all modern civil and political rights. And they didn't immigrate there in order to live under military occupation. They want to feel that they brought Israel with them to the occupied territory. And so the Israeli government, the Israeli parliament, and the Israeli army have tailored different techniques to apply Israeli law to Israelis when they are in the occupied territory. So when I travel from Tel Aviv to the occupied West Bank, I travel with a bubble of Israeli law that surrounds me. And if I commit a crime in the West Bank, I will be tried according to Israeli law by Israeli courts, and I will be investigated by the Israeli police. While my neighbor there, a Palestinian, will be tried by a military court according to military orders and according to the laws that apply there. So we have Israeli law that is applied personally, extraterritorially, outside the borders of the state of Israel to Israelis in the West Bank. So that's one thing we need to remember, that Israelis are being governed by Israeli law even when they are outside the borders of sovereign Israel in the West Bank. Second thing is, and with that I'll end my answer to this question, Israeli law the Israeli High Court of Justice has applied Israeli administrative law, the laws that pertains to what is permissible and what is prohibited, the length of the width of the powers of public institutions and the different limitations on their powers to the conduct of Israeli authorities when they are in the occupied Palestinian territories, may it be the West Bank or the Gaza Strip. So when the Israeli army or the Israeli Nature and Parks Authority or the Antiquities Authority are acting in the West Bank, the Israeli High Court has the power to judicially review whatever they do, their acts, according to Israeli administrative law. So also Israeli administrative law has been applied not only when Israeli authorities acts are being conducted vis-a-vis the Israeli settlers, but also when they act and apply their powers to Palestinians. And the last thing I'll say is that East Jerusalem, we all have to remember, was annexed by Israel in 1967, and Israeli law and Israeli administration and Israeli judiciary have all been applied to East Jerusalem. That is a direct violation of international law that prohibits, with no exceptions, annexation of land conquered by force, one-sidedly. So I'll stop here.
Thank you, Michael. So let's go to the next question. What is the Supreme Court's approach to settlements, Palestinian human rights challenges such as home evictions in East Jerusalem, displacement of Palestinians in the West Bank, denial of housing permits, as well as destruction of private Palestinian infrastructure?
So I said before, David, that building settlements is a violation of a specific, very clear prohibition that is enshrined in international laws of occupation, which is part of international laws of war. And I want to say that this is not my position. This is not Michael Sfard's position or Peace Now's position. There are not many issues, not many legal questions that enjoy a consensus that is, I would call it a wall-to-wall consensus. I'm sure you all know that the legal profession flourishes when there are disagreements. This is what lawyers do. They disagree, they argue. And so usually on every legal question, you have many positions and many schools. But this is one of those very rare issues, legal issues, where there is a complete consensus among international law scholars that the Israeli settlements are all illegal, all of them until the last one, those in the West Bank, those that were in Gaza, those who are in East Jerusalem, they're all, to the very last of them, completely illegal, that international laws of occupation have enshrined this prohibition on establishment of settlements, especially to avoid and to prevent the kind of reality that we're seeing today in East Jerusalem and in the West Bank, where the conflict is knotted, it's completely unsolvable because of the demographic changes that were made by the occupying power. And of course, with it comes the complete diversion of all the resources of the occupied land to the settlers on the expense of the indigenous occupied people. So when I said all of this, then it begs the question, what did the Israeli court say about it? I mean, the Israeli court is a professional, and the Israeli judiciary is professional and independent. They don't get orders from the government on how to rule, and they do apply, or they are aiming to apply, international law. Do they not know what I just told you, that this is a clear prohibition? So the story is that the Israeli Supreme Court was faced for the first time a direct challenge to the legality of settlements in 1991. Before that, there were a few cases that did not raise directly the question of whether it is allowed to create settlements, but rather there were questions about specific settlements and whether they were legal or illegal through land laws and the question of land and property rights. But there in 1991, Peace Now, the biggest and oldest Israeli peace group, has challenged the court by bringing a petition, the Israeli High Court, which is a bench of the Israeli Supreme Court, a challenge to a question on the legality of settlements at large. And the Israeli Supreme Court has decided to avoid answering the question. In a very famous or infamous decision, the court said, yes, there is a legal answer to the question of whether settlements are legal or not. But we will not step on this legal mine. That's how they called it, a legal mine. The petitioners are, of course, at liberty to place this legal mine in front of us, but we are not obligated to step on it. And they said something that is very similar to the, I don't know if you know the American doctrine, the political question doctrine, which says in very, very broad terms that when a question is primarily a political question rather than legal, then the courts should avoid it. This is a very, very problematic doctrine. And in Israel, it was applied to the question of legality of settlements. The court said, yes, there is a legal dimension to the question of whether settlements should be erected or not. But primarily, this is a political question which should be left to the political echelon and to the political field. The problem with that and of course, dismiss the petition, allowing the settlement enterprise to flourish, because that's the implication of such a ruling. I just want to say one thing about that ruling, which we all suffer from until this very day. Leaving the question of settlements to the political field means leaving it to Israelis only, because Palestinians are not part of the political game. As I said before, they do not have the right to vote. They do not have a right to be elected. They don't have representation in Israeli political corridors. So basically what the court has said, that it is okay for such a question that if affects the lives of millions of people for generations to be decided only by the community that enjoys settlements, and not by and not allow the community that suffers from that to be part of the decision making. So that's how the Israeli judicial system has been treating the question of settlements in general. In particular, the court has always been very clear that settlements should not be built on private Palestinian land. So the court has been active from the late 70s and until this day in providing some kind of safeguards and protection to Palestinian landowners so that their land would not be expropriated for the settlement project.
So to what extent is the Supreme Court action in the territories limited by the political environment, which currently appears to be favorable to the occupation? So if you have a government that is more liberal, does it affect Supreme Court's decision as opposed to a more illiberal government?
Look, the Israeli Supreme Court had different generations of judges, and the answer to this question changes from generation to generation. As I said before, the Israeli Supreme Court and the Israeli judiciary at large is an independent judiciary. They are not, the judges are not being told what to rule. They have security to stay in office until they are until they reach 70, and they are not. The politicians cannot threaten them with overthrowing them from the bench, and there are all kinds of safeguards that you have in many other countries that aspire to be democratic and liberal, so that the judiciary would feel secure to rule according to their conscience and the law, and not be intimidated by the politicians. However, in recent years, the Israeli political culture has changed in a way that the criticism of court decisions was not confined to speech and presenting a different opinion or even harsh criticism of the court, but rather threats to cut down the powers of the Israeli Supreme Court, for example, through legislation. And in the last 20 years, we've seen the Israeli right adopt the kind of methods and tools that you find in the alt-right in America and in the conservative right in other places, where the idea is to change the constitution of the country in a way that would take away some of the main powers that the Israeli judiciary has. For example, the power to review the constitutionality of laws that are being legislated by the parliament. So we have a Supreme Court that, we have a judiciary that has the power to declare that laws, for example, the law of the regularization law, the law that the Israeli parliament has enacted in 2017, which basically confiscated, expropriated private land that belongs to many Palestinians, that on which settlers have been trespassing into and building outposts or unapproved settlements. So this law, for example, was declared unconstitutional by the High Court of Justice in a petition that Peace Now filed, and other organizations also, and I was involved in and litigated on behalf of Peace Now. And for example, this is a very important power that the judiciary has over the parliament as a gatekeeper, so that the parliament and the majority in the parliament will not abuse its power. And there is constant threat that this power will be taken away through legislation by the legislators. And so the Supreme Court has been extremely aware of the threat that rulings that provide protection to Palestinian rights will have on its future as an institution. And since the Palestinians are not a constituency, it is almost illogical for the court to take their side, quote unquote, because they will not benefit from it. They will not, there are no Palestinian representatives that will later on defend the court from the attacks of the Israeli right. So as a lawyer that appears in the Israeli High Court of Justice for the last more than 20 years, I can tell you that I definitely feel the change. I definitely feel that the court has become more conservative, more cautious, less open to provide protection to violation of Palestinian rights. It's not only because of that political attack, but also because the Israeli right has been in power for the last 15 years and had the power to appoint judges. And so we have a completely different bench that we had 15 or 20 years ago. And so many of the judges that are today sitting in the Supreme Court are themselves conservative in the sense of the Israeli-Palestinian conflict. They would allow more leeway for the government and the army and the settlers. They are more nationalistic and are ready to accept that national interests, or what the government thinks is our national interest, will trump individual rights of Palestinians. So yes, we are in a completely different era in that sense.
Thank you, Michael. New question. Should the situation in the West Bank be called apartheid or just discrimination against Palestinians? Can you define for us the term apartheid in the Israeli context, which, as we know, applied to South Africa at the time? We know this is a very sensitive matter for many Israelis and many Jews in diaspora.
Yes, and this is a topic that I give lectures on, full lectures, not just a question within a webinar. And I also wrote a very lengthy legal report, which any of you can read, for the Israeli human rights organization Yesh Din, and you can all find it on Yesh Din's website. We also have an English version of this legal report. I do not have to define apartheid. Apartheid is defined in international law, very clearly defined. It is defined as a crime against humanity, which is an international crime. International crimes are divided into several categories. There are crimes against the peace or crimes of aggression, which are crimes that pertain to opening war or using force against without a justification. There are war crimes, which are crimes committed mainly by combatants in the field of combat. And then you have crimes against humanity, which are heinous crimes that are committed when a civilian population is being targeted in a widespread manner. And one of the crimes against humanity that has been recognized by the international community is the crime of apartheid. Just to finish, that the fourth category of international crimes is, of course, the crime of crimes, genocide. So the crime of apartheid is a concept of international criminal law. Of course, the roots of the concept are in the historical regime in Southern Africa between the 1940s and the 1990s. But the specific regime that we had in South Africa was the source and the inspiration for the international prohibition, the international crime of apartheid. And you don't have to clone the regime in South Africa in order to commit the crime. Any regime that will meet the definition of apartheid there are two international treaties that define it. One is the International Convention for the Suppression and Punishment of the Crime of Apartheid, a 1973 international treaty that was signed especially to combat the apartheid regime in South Africa. And then you have the Rome Statute of the International Criminal Court, which was opened for signatures in 1998 and then became active in 2002, which has a definition of the crime of apartheid. And basically, the crime of apartheid is being defined as inhumane acts that are committed in a context of a regime in which one racial group dominates and oppresses another racial group with the intention of maintaining, perpetuating that regime. So the idea of an apartheid regime is an idea of a regime where one group of people is subjugating, is dominating and oppressing another group of people with an intention to perpetuate that domination and oppression. And that domination and oppression is done mainly through denial of rights and through denial of resources. That's how it is done. Now, for a regime of occupation in which there are settlers, by definition almost, is a regime of oppression and domination of one group over another. Because when you have Israel, if we'll take the example of the Israeli occupation, when you have Israelis who have all the civil and political rights, as I said before, and they enjoy all the resources of the land because they have the political power to enjoy it, and you have another group that is being stripped of their civil and political rights, they have no say in the corridors of power where their fate is being decided, then by definition, this is a regime of domination and oppression of one group over another. However, throughout the years, I rejected the notion that this is an apartheid regime for the simple reason that one element was missing. And that element was an intention to perpetuate that regime. And I said, Israel and Israelis want peace, and they want two states. and they have began and there was the Oslo Accords and the peace process. And so you cannot say that we have an intention to maintain that regime of domination and oppression. But I think that we have to be honest with ourselves. And I think that when we look at the evidence before us, it is impossible today to say that Israel does not have the intention to eternalize, to make the occupation eternal. And we have seen that in the last decade with governments that clearly stated that we that we will be there forever, that that our policy is a policy of gradual annexation. And so I think that today, with all the evidence that we have, for me, it would be one of my easiest cases if I would be asked to prove in court that the Israeli the Israeli governmental policy is a policy of perpetuating our domination over Palestinians and oppressing them. So unfortunately and embarrassingly, I had reached a conclusion, and in my report, it's much more elaborated than that, that yes, the crime of apartheid is being committed in the West Bank specifically. It is committed by Israelis, and the victims are Palestinians.
Thank you. My last question is, what are some success stories in the legal fight to curtail settlements? And what are some critical upcoming cases? And what do we mean? What do you mean by success? I know in your book, The Wall and the Gate, you have a specific chapter on what success and failure means, which is quite counterintuitive.
Right.
So I'd like to hear what you have to say about it.
Yes. So I think when we talk about legal struggle, especially litigations, because not all legal struggles are conducted in a court of law. There are legal struggles that are conducted in other administrative bodies. But when they are conducted in court, usually it is very easy to look only at the final result, at the bottom line of the specific litigation. And then it's easy to decide whether that was a victory or a defeat. If the petitioners have managed to convince the court to provide them with the remedy they sought, then this is a victory. If I represent a Palestinian whose olive grove is going to be uprooted, and I file a petition and I ask the court to issue an injunction that would prevent my client's grove from being demolished, then and I manage to do it, this is a victory. And if I don't get this injunction, then this is a defeat. But not all victories lead to success, and not all defeats lead to failure. And what do I mean by that? I mean that there's a completely different layer that has to be explored in when strategizing legal struggles. And that is the question of the long-term effect of litigations on the struggle. Sometimes there are victories that face a backlash. And while in the specific case you won, the backlash changes the whole field, and things deteriorate. The policy becomes worse than it was before. And vice versa. Sometimes losing in court ignites a process of public awareness and public discontent that eventually leads to a change in policy, which is a success. So success is not always driven by victories, and failure is not always the outcome of defeats. And in the struggle, in the different legal struggles and litigations we had in relation to the occupation, we had success stories and we had many failures. And some of the success stories have to do with the settlement project. The settlement project in general has managed to flourish. And today we have between 600 and 700,000 Israelis that live outside or east of the Green Line, the ceasefire line between Israel and Jordan. And that is a big, big failure. But I think that the overall litigations that dealt with settlements have managed to make it difficult for the settlers to use or to grab a private Palestinian land. It began with the 1979 case of Elon Moreh, but also the Peace Now cases of the recent decade on Amona and Migron and other outposts that are basically settlements that were created or established or erected on private Palestinian property. And we have managed to convince the court to evacuate them. The regularization law, which I mentioned before, that was the backlash for all these cases. The Israeli parliament passing a law that allows basically to grab, to steal, to rob Palestinians of their lands and allocate them to the robbers. That's what this law was about. And we've managed to convince the court to declare it unconstitutional. So we had some successes. I think there are several important cases you should follow in today's Supreme Court, cases that deal with Sheikh Jarrah and Silwan, two neighborhoods in East Jerusalem that are facing a tsunami of evacuation orders. It's a very long story why they're facing these orders. And I'm not going to get into this, but this is very, very important. And on October 25th, we have a hearing in the Israeli Supreme Court in the first case, in the first evacuation order case that comes from Silwan, that reaches the Supreme Court, began in the magistrate court, moved to the district court, and now reaches the Supreme Court. So this case is extremely important. There are cases regarding the question of the desire of the Israeli Attorney General to use a doctrine that is called the market regulation doctrine, which allows land that was mistakenly taken by settlers to be passed, the title will be passed to them. And we had a hearing actually today, and this is something that will affect many of the invasions to private Palestinian land. So we have many of those. And I think I'll stop here and leave time for more questions, because I can really speak about these things for hours. So I'll stop here.
Yes. Michael, Michael, I'd like to react to some of your comments. You stated that the Supreme Court is independent and professional, but that lately it has shifted to the right because of changes in the composition of the Supreme Court. Given that, how legitimate and credible at the international level are the decisions of the Israeli Supreme Court?
The Israeli Supreme Court is judged in the international legal community according to the content of its rulings. And in recent years, its rulings have departed very much from what is seen as the correct interpretation of international law. I think, and I haven't done any study on this. This is just my impression from being involved in many legal communities around the world, that the Israeli Supreme Court has lost a lot of its credibility among in the legal profession. It is definitely true that in the 80s and 90s, the Supreme Court of Meir Shamgar and Aaron Barak, who have been very helpful, by the way, to prolonging the occupation and allowing settlements, but nevertheless were also active in some cases in protecting the rights of Palestinians and curbing the acts of the Israeli government. These courts have enjoyed tremendous appreciation and recognition and had a very, very good reputation. Israeli Supreme Court cases were taught around the world and were translated. And I think from my experience that this is not the case anymore. When the Israeli Supreme Court rules on a matter, it is not received around the world in the same way that it had in past years.
Thank you. So here's my last question. Can the Israeli-Palestinian conflict be solved through legal action, whether in Israel or before international courts, given that the policy of occupation has been, as you said, a core policy of Israeli government, and that occupation is no longer temporary?
The Israeli-Palestinian conflict will not be solved in a court of law, but the law will not be, law and litigation will not be in the driving seat of the movement to end the occupation. But law and litigation will always be there as an aiding feature to the movement for peace and the movement to end the occupation, and a very valuable assistant. At the end of the day, in order for the occupation to end, in order for peace to be reached, achieved, there must be a minimum political force on both sides and the international community that will drive the parties to reach that peace agreement. Law, litigation will help, might help. By the way, we did not talk in this conversation we had about the negative effects that law has on the situation, because law is not only a shield. Unfortunately, law is also a sword that is used by the Israeli authorities in order to deepen their hold of the Palestinian lands. But law and international, and mainly international law, I'm sure will have a very important role in helping the parties when there is enough will to reach an agreement that will end the occupation and will provide us with a just and lasting peace in this region.
Thank you very much, Michael. Okay, now I will pass the mic to Gabriela so that she can handle questions from the audience.
Thank you very much, David. So we do have a lot of audience questions. We have till about 1:15 to try to get through as many as we can. I'm going to put two together because they're similar. One comes from Mary Rubin, and he asks, since there was never a country of Palestine, should not the West Bank be a disputed territory? So considered disputed. And this is somewhat similar to a question asked by Jack Zygmunt, who asked that the land had no legal ownership post-British mandate, so how can annexation not be legal? Who else has legal ownership claim? I think there was, of course, a land called Palestine, but I think the question is, both of them are asking about the pre-48 situation, and I think you want.
So this is the classic Israeli argument that is, of course, being almost unanimously rejected by the international community as a whole. Disputed lands, this is a correct description of the West Bank and maybe even Gaza Strip and definitely East Jerusalem. They are disputed. That's not a legal concept. That's a political description of what's happening, but that's not a legal concept. There are no laws of disputed territories. What's the status of the land? Disputed, there is no such thing as disputed, the laws of disputed lands, there's no such legal status. So the fact that they are disputed means that there is more than one party that has claims for these lands. Fine, Israel may have claims for this land, there are still occupied lands. And that connects me to the other question. I don't know why, but people tend to forget the most important binding international resolution that created the state of Israel. The partition plan. And the partition plan of 29th of November 1947 has allocated this land to two states, Palestine and Israel. And this is why these lands, according to the partition plan, as changed later on to the Green Line, and was acknowledged by the international community that the Green Line is the new partition line. This is the land that is allocated by international law and through the international community to the Palestinians. So no, Israel has occupied the West Bank. It has had a sovereign. The sovereign has never materialized its sovereignty. That's true, because from its inception, it was under occupation. And when Jordan annexed the West Bank and East Jerusalem, it violated international law, and no country in the world recognized the Jordanian annexation because of the partition plan that is a binding decision of the international community. So it is occupied territory, and it does have a sovereign, and that's the Palestinian people.
Thank you. This question comes from Jill S. Jacobs. How do the Oslo Accords impact the powers vested in the occupying power vis-a-vis the Geneva Convention? So did the Oslo Accords change anything from what you had described at the beginning?
Nothing. The Oslo Accords were supposed to, and I believe Yitzhak Rabin and I believe the others that were the architects of Oslo, that it was meant to be an interim phase towards towards two states. By the way, there's nowhere in the Oslo Accords there is a mentioning of a Palestinian state. So the Oslo Accords, without the Torah Shebe'al Peh, without the unwritten aspirations that I believe were there, is nothing but a transfer of administrative power by the military government to a local government, a transfer that at any point can be taken away, and it is done on a daily basis, that the Israeli military is taking back powers that it provided the Palestinian Authority, whether for a specific length of time or in a specific topic, And so in a way, legally speaking, the Palestinian Authority is part of the military government.
So there are a couple of questions somewhat similar, touching on the distinction between what's going on in the West Bank and what's going on within Israel, within the Green Line, regarding the term apartheid. So would you, do you make that distinction? And a similar related question is, do you support the BDS movement? Would you support it if, this comes from David Korn, would you support it if it were just limited to outside the Green Line?
Well, you will not find any product from settlements in my home. And I definitely, I definitely think that the ethical thing to do is not to provide any economic support to the settlement project. So in this sense, I definitely, I support, and I myself engage in boycotting Israeli settlements and settlement products and settlement industry. I'm not a supporter of the BDS. I do believe that they have a right to engage in political boycotts, and this is part of their part of their right to freedom of speech. And I hate the kind of automatic attribution of anti-Semitism to anything that has to do with criticizing the state of Israel. But I'm not part of the BDS, and I try to be more focused on and when I boycott an entity, it's because they have a direct effect, or the direct responsibility and individual responsibility to the wrong that I attribute to them. So a blanket boycott is not something that I'm part of. As for the question of apartheid in Israel, it would be very easy for me to answer this question if we did not have the occupation. Then I would say, yes, Israel has an Arab minority that is being discriminated systematically. There's a systemic discrimination against them. They are suffering from discriminating policies and practices, and they are second-class citizens in many aspects. But this is something that does not reach the level of apartheid. There are many countries where minorities are being discriminated against, and that does not make them an apartheid states. The question becomes more difficult because of the occupation. And I'll give you an example not from Israel. I'm sure you all agree that there is a systemic, immense, historic, institutionalized discrimination against Blacks in America. But they still enjoy, on paper, equal rights, equality before the law. And the fact that they are discriminated against is something that is known. But we do not ascribe apartheid to the American regime. Now imagine that they have an occupied territory where Blacks are being subjected to different laws from whites. They are being oppressed by the whites, and they're being, and all the resources of the land are being taken from them and allocated to the whites. Then the whole thing seems different. And the question of why Blacks are being discriminated against in America has suddenly a different aura when you have this clearly apartheid territory that is being ruled by the same government. So I think that the discrimination of Palestinians with Israeli nationality does not reach the definition of apartheid in and of itself. But I think that when you have the occupied territories and the apartheid that is being exercised there, it reflects on the discrimination of Arabs in Israel. And that is very, very problematic. I know that it was a lengthy and complicated, complex answer, but that's the reality.
Oh, it's a very interesting answer. Thank you. This question comes from Shahid Akhtar. I'm not sure if I pronounced it right. Apologies if I did not. Is resistance the legal right of the occupied people?
Yes. It's very simple. The answer is yes. The question is not whether resistance is a legal right. The question is what kind of acts of resistance are legal and which are not. But resistance is definitely a right.
Can you just elaborate what acts are legal and which are not?
There is this takes a whole semester to learn about. But basically, the laws of war, the laws of warfare, provide answers to the question of what is permissible and what is not. Attacking citizens is not permissible. When occupied people resist to the occupation and fight it, if they target civilians, then it's not a legal way to resist, for example.
Okay.
And I think this is the most important aspect.
Thank you. Okay, this question comes from Meyer Simiatsky. Again, I may not pronounce it right, writing from Toronto. Michael, are you making headway building support for your views and analysis among Israelis? And there was I guess a related question coming from somebody anonymous. How can Israel be stopped from making all these changes, especially the demographic changes in the occupied territories? Maybe not.
So I think I'm, I should remind the people that are in this webinar that I'm a lawyer. I'm not a politician and I'm not a leader. I am part of Peace Now, and I think one of the missions of Peace Now is to convince as many Israelis as possible that we have to end the occupation, that it is not only the right thing to do when it comes to human rights of the people that we occupy and had not known a single day of real freedom in the last 55 years, and probably even before that. But it's also the right thing to do for us, for the Israelis. And I think that we're in a difficult time in the sense that the Israeli society has moved very much to the right. But I truly believe that this will change. And I think that with the help of people around the world, like members of Canadian Peace Now, I think that that we should be preparing ourselves for the moment when it will be, ripe, and when it will be right for the Israeli society to change its direction. So we're working very hard. We're not, I'll be very frank, we're not very successful at the moment, but I think times are changing and will change. We had a decade where Europe was busy with the refugee crisis and with the Brexit, and America, was with Trump, and the whole atmosphere was that we can do whatever we want. And indeed, the Netanyahu government has done a lot of damage by perpetuating the occupation and the settlements and making headways towards annexation. This has stopped considerably, and that's a good start. I mean, especially the idea of annexation that was lifted off the table. But now it's not enough just to prevent the bad things from happening. We definitely have to work very hard now to change course.
Thank you. So a question coming from Lawrence Englander. It's a little bit similar, and you've covered the ground a little bit, but it's still, I think, interesting the way he states it. So what legal significance is there to the fact that a significant proportion of Palestinians are a hostile population, not only through violent acts of resistance, but also through the insistence of full return, which would be mean the dismantlement of the state of Israel? So I guess is there any legal weight to the fact that that there is that resistance?
We're in a conflict. I mean, I'm not sure I understood whether the person who posed the question means the Palestinians under occupation or the Palestinians with Israeli citizenship, the Israeli Palestinians. If you meant the Palestinians in the occupied territories, well, we're in a conflict, and we have to end this conflict. And as long as this conflict is alive, then yes, there will be millions of people who we subjugate, and they want to be freed, and so they will fight against the oppression. I think that's what we would have done instead of them. That's what we've done before the establishment of the State of Israel. I remind us all that the Jewish national movement had paramilitary groups that resisted the British mandate and worked to establish the State of Israel. Some of them have engaged in acts of terrorism against civilians. So, it's not something that only Palestinians do. This is something, unfortunately, that happens in struggles for national independence in many places in the world, including us, the Jewish National Project. So I believe that when the Palestinians eventually will receive their independence, which is legally and morally what they are entitled to, just like us, I think that will reduce considerably the amount of violence, and and this is what I do in my career, trying to bring that day.
Okay, I think we have time for maybe two more questions quickly. So this comes from John Snipper. Are you asserting that the resolutions of the General Assembly of the UN are of themselves international law? And if they are not, what is required for them to become law?
The decisions of the General Assembly are not binding, except when it comes to mandatory areas and the budget of the UN. So the partition plan is a binding resolution. The resolution that adopted the partition plan is binding. And this is a Hasbara thing. This is an Israeli Hasbara bullet point, that the partition plan is not binding. First of all, how much chutzpah Israeli needs to have in order to trash the partition plan that is the basis of the Jewish independence? And second, it's just not true. Legally speaking, it's not true. It is binding.
Okay. This question is maybe not exactly in your field, but we'll ask it anyway. David Hughes would like to know how the Abraham Accords have affected the peace process and the legal struggle against the occupation.
Sorry, can you repeat that? I was not.
Okay, sorry. How have the Abraham Accords affected the peace process and the legal struggle against the occupation?
I don't think they had any effect on the legal struggle, but I do think that the Abraham Accords at a certain point endangered the little incentive Israelis had to work towards a solution of the conflict with the Palestinians. Because the whole David Accords idea of Netanyahu was to show that we can bring peace agreements and skip over the Palestinian question. Now, of course, for the left, it was a difficult place because we support peace agreements. And I also support the peace agreements with the Gulf states, although we were not really in war with them. Let's be honest about it. But nevertheless, this is an important. These are important agreements, and now that time has lapsed since they were reached. I think the Israeli public and the Israeli leadership has acknowledged or realized what should be clear, that the Palestinian question is the most pressing, the number one most important question for the future of the state of Israel and the Israeli society. And you cannot skip over that question. If the idea by Netanyahu was that the David Accords would somehow hide the Palestinian issue for years to come, it didn't materialize, it didn't happen.
Well, I'm sorry to say our time is just about up. Michael, thank you very much for your thought-provoking, excellent talk, and for all the important work you do. Thank you, David Cohen, for your pertinent questions. And thank you to all those in the audience who stayed with us. I do want to remind you again to please visit our website, peacenowcanada.org, to learn more about us. And please consider a donation because we count entirely on the support of people from the public, people like you. Stay tuned, please, for more great events. We have one coming up on October 31st, which will be an update on what Peace Now is doing in Israel. And our guest will be Dana Mills, a representative of Peace Now. And that's to conclude. I wish you all well, and thank you again for joining us.
Thank you very much.